1. A jury trial commences with the selection of the jury. So when does jury trial commence? With the selection of the jury. 2. A conviction plus the sentence imposed thereon is a judgment. So what's a judgment? It's a conviction plus the sentence imposed thereon. That's a criminal judgment. 3. Which of the following is not an accusatory instrument? So you have to know what's an accusatory instrument. An information, simplified information, prosecutor's information, superior court information, felony complaint, misdemeanor complaint, and an indictment. That's it. That's it. Not a summons, not a criminal summons, not a superior court summons, not an appearance ticket, not an arrest. None of those are accusatory instruments. It's complaint, information, or indictment. And then there's 4 categories of information, 2 categories of complaint, and indictment stands alone. 4. The function of a bench warrant is to what? And it's to achieve defendant's appearance for a purpose other than arraignment. So some other purpose, but not arraignment. That's a bench warrant. It's called the same thing whether it's in superior court or a local criminal court. Number 5, okay, this is false because an appearance ticket is a written notice. It's not a process. A process of a local criminal court requiring a defendant to appear for arraignment, that's a summons. So just be very careful. There's a big difference between a written notice by a peace or police officer, that's an appearance ticket, directing defendant to appear in a court on a specific date, and criminal summons, which is a process of a court. With the appearance ticket, the court does not have jurisdiction yet because there's no accusatory instrument filed. So when there's a criminal summons issued, that means an accusatory instrument has been filed and the court has jurisdiction. That's why it's a process of a court. Okay, number 6, sentence means 2 things. It's imposition and entry of sentence upon conviction. So when you hear sentence, you think imposition and entry. So sentence means imposition of sentence upon conviction and entry of sentence upon conviction. You need both of those things, imposition and entry. Number 7, this is kind of a tricky one if you didn't know that justice courts are actually not necessarily courts of record. So if you didn't know the town and village courts, which are the justice courts, are not courts of record, it would be a little tricky. But the best answer here is that the criminal courts of the state of New York are local criminal courts and superior courts. So the answer is D, 1 and 4 only. That's what the criminal courts are. Now, of course, that includes Supreme and County, district courts, and all sorts of local criminal courts. But the best answer here was 1 and 4. 8, which of the following is the best description of a superior court? Again, best answer E, Supreme or County Court. So a superior court is a Supreme Court or a county court. In the city of New York, it's obviously Supreme Court, criminal term, and in counties outside the city of New York, they have county courts. Number 9, an indictment must charge a person with at least 1 crime. So it has to have at least a misdemeanor or a felony. It has to have at least a misdemeanor grade in the indictment. Yes, you can have an indictment where the highest charge is a misdemeanor. Doesn't happen very often. But the way that they can trick you on this is by saying it has to have a felony. It does not have to have a felony. It just has a crime. Has to have a crime in an indictment. Same thing with the superior court information, which again makes no sense, but that's what it is. Okay, so a criminal action is commenced by the filing of an accusatory instrument. You must commit this sentence to memory because it is a gift question if they give it to you. So again, let's do number 10. A criminal action is commenced by the filing of an accusatory instrument, period. How is a criminal action commenced? When an accusatory instrument is filed. What is the effect of filing an accusatory instrument? And the answer is a criminal action is commenced. Must know that. It's not when the person gets arrested. It's not when a summons is issued, whatever. 11. This is true. This is a relatively new statute. A district attorney may also mean an assistant attorney general or a special prosecutor, an inspector general for the protection of people with special needs, or his assistants, or the inspector general of New York for transportation, or his deputies. Just take a look at 1.20 sub 32. Again, Because 12. A prosecutor's information can be filed in a local criminal court. C. A non-jury trial commences with, and it's 1 or 2. So the first opening address, if there be any, and if neither party opens, then it would be when the first witness is sworn. And the reason number 3 is wrong is because if the people don't make an opening, rather, the defendant might open. And if the defendant opens, that's when the trial would commence. 14. An information may charge a person with basically anything except a felony. So 2, 3, and 4. Violation, misdemeanor, or a traffic infraction. A decision by a court after a non-jury trial upon a defendant's guilt or innocence of the charges submitted to it and considered by it is called a verdict. So it's still called a verdict even though the jury is not involved. Verdict means the announcement, so D, the announcement by a jury or a judge in the case of a non-jury trial of its decision upon defendant's guilt or innocence. 17. This is new for 2018 and 2019. An adolescent offender means a person charged with a felony committed on or after 10/1/18 when he or she was 16, or on or after 10/1/19 when he or she was 17. 18. Which of the following may occur in or be issued by a superior court other than the youth part? And it's criminal summons, yes. Warrant of arrest, no, because it says other than a youth part. So we're talking about the old rule, which is a Supreme or county court does not issue a warrant of arrest. They issue a superior court warrant of arrest. 3. Plead guilty to any crime. That's true. Any misdemeanor or felony. 4 is a bench warrant. Remember, bench warrant is called the same thing, whether it's in a local criminal court or a superior court. 19. Superior court judges may, in their discretion, sit as local criminal courts for the purpose of conducting arraignments, issuing warrants of arrest, and issuing search warrants, not conducting misdemeanor trials. So it was C, all except 4. So remember, when superior court judges are sitting as local criminal courts, any warrant of arrest that they issue is executable anywhere in the state, and they can conduct arraignments, warrants of arrest, and search warrants. That's what they do. The fucking chief administrator has the power to adopt, amend, and rescind forms for the efficient and just administration of the CPL. Ha, that's cute, right? Okay, so here we go. 21. This is a tough one because you had to kind of be careful. Which, if any, of the following statements are true regarding courts exercising criminal jurisdiction? 1. Superior courts have trial jurisdiction of all offenses. This is true. Now, they only exercise the jurisdiction of petty offenses when it's attached in an indictment or superior court information. 2. Superior courts have exclusive superior courts. 2. Superior courts have exclusive trial jurisdiction of felonies. That's true, because the only place that you can take an action to judgment in a criminal proceeding is in a superior court if you're talking about a felony. LCCs have trial jurisdiction of all offenses other than felonies, and that's true. 5. LCCs have trial jurisdiction of misdemeanors concurrent with that of superior courts, also true. 6. Local criminal courts have exclusive trial jurisdiction over petty offenses. Now, they consider that to be true, but obviously if a petty offense is named in an indictment, then it would be in superior court. And 7. The fucking chief administrator shall establish a youth part of the superior court in every county in the state. And that is also true. So, all the above. That was a nice study question for you. Read that a couple of times and make sure you know all that shit. 22. In counties outside New York City, the fucking chief administrator may authorize use of electronic filing in a county court with the approval of the administrative board of the courts and the agreement of the county clerk. It's weird because you don't often hear the county clerk when you're talking about criminal stuff, unless you get into like bail. But this is the county clerk has to approve it. This is a pretty new one here. I think it was in here around 2012. Number 23, the fucking chief administrator may eliminate the requirement of consent regarding e-filing in Supreme County courts of not more than 6 counties, provided he shall not eliminate such requirement without consent of the DA, the county clerk, and the criminal defense bar of the county in which such court presides. So it was 1, 2, and 3 only, not the administrative judge. Strange. That's why I put that in the question, because I thought it was weird. Like, you got to get the criminal defense bar, the DA, and the county clerk to agree, but not the administrative judge. Okay. 24. Prosecution for which of the following may be commenced at any time? Class A felony, rape first degree, aggravated sex abuse first degree, a crime formerly defined in 130.50 of the penal law, and I think that's like when you rape someone in like anal rape, criminal sex act, first degree, course of sexual conduct against a child in the first degree. And the reason that those are in there is because those are B violent felonies. So it's any A felony plus a B violent sex felony, basically. 25. A prosecution for a B misdemeanor must be commenced within 2 years. 26. A prosecution for a Class E felony must be commenced within 5 years. 27. Prosecution for any misdemeanor as set forth in tax law in Chapter 46 of Administrative Code of New York City must be commenced within 3 years. And tax has 3 letters. So TAX, 3 years. 28. Generally, motion dismissed must be granted if people are not ready for trial within 6 months for felony, 90 days A misdemeanor, 60 days B misdemeanor, and 30 days violation. Obviously, the way the statute is worded, just know that it says like not more than 3 months, blah, blah. Okay. But basically, these time rules are 5 years, 2 years, 1 year for the timeliness of prosecution. And then it's like the release on their own recognizance in 180/80 or 170/70 is not the 120 or the 144 hours. This is different. This is, you're talking about they're not ready for trial. So for a felony, it's the 90 days, A misdemeanor, 30 days, B misdemeanor, 15 days, and violation 5 days. So that's the ROR, which is different than speedy trial, which is actually dismissing the entire case. The other thing I talked about, the release on the own recognizance, which is the 90, 30, 15, 5. That means the case is still going on. It's just that the person has to get out. The one with the speedy trial, the case is actually dismissed. So that it's much, just remember, it's much longer because you're talking about actually dismissing a case. So that one's the 6 months, 90, 60, 30. The 6 months, 90, 60, 30 is the speedy trial. Timeliness of prosecution is 5 years, 2 years, 1 year. And release on own recognizance is 90, 30, 15, 5. With timeliness of prosecution, they don't split up the A misdemeanor or the B misdemeanor. It's 2 years for any misdemeanor. Except like the tax thing and environmental conservation thing, which is 4 years. Taxes for environmental conservation is 3. Okay. Let's move on. 29. Here's speedy trial. 30/30. In general, a prosecution for felony must be commenced within 5 years, for a misdemeanor within 2 years, and a petty offense 1 year. What does 30/30 not apply to? And it's basically all the murder, manslaughter, and homicide statutes. Everything else, they have to dismiss it within, if they're not ready for trial, within 6 months. Which, if any, of the following are local criminal courts? And city court, yes. Town court, yes. New York City criminal court, yes. 4 is wrong because it says U.S. district court. So if it didn't say U.S. district court, it would be okay. It would just say district court, and that would be fine. But because it says U.S., that's a federal court. That has nothing to do with the New York courts. So that's wrong. And village court, yes. So it should have been B, all except 4. A prosecution for a misdemeanor, 2 years. Petty offense, 1 year. That was 32 and 33. Where a defendant is, 34. Where a defendant has been committed to custody of the sheriff, In a criminal action, he must be released on bail or ROR upon such terms as may be just and reasonable when the people are not ready for trial within 5 days when there's a violation and no crimes, 15 days where it's a misdemeanor punishable by a sentence of imprisonment of not more than 3 months. So basically a B misdemeanor. And the time periods are measured from when he's committed to the custody, because this is just they're getting him released on bail or ROR. The case is still going on. Then the 30-30 question, for a misdemeanor not more than 3 months, so like a B misdemeanor, motion to dismiss must be granted when people are not ready for trial within 60 days. True or false? For the purpose of CPL 30-30, where a defendant has been served with an appearance ticket, the action must be deemed to have commenced on the date defendant first appears in local criminal court in response to that ticket. That is true. So why does this matter? Why is this in here? The reason it's in here is because, let's say that you get an appearance ticket. You come to court on the day of the appearance ticket, but for some reason the cops, they never filed the paperwork. They never gave the court your ticket. Now you're sitting around all day. It takes a month to find it. No, it starts the day that you came in response to that ticket. 37, a criminal action may be commenced in a superior court by, 1, the filing of a felony complaint in the arraignment part. Nope. 2, the filing of a felony complaint charging an adolescent offender with a felony in the youth part of superior court. True. 3, the filing of a superior court information in a superior court after defendant waives prosecution by indictment. No. Because the only way you get to superior court information is if you are waiting for the grand jury to hear your case. That's the only time you're getting it. So there's already been a felony complaint filed against you. 4, the filing of an indictment in a superior court against a juvenile offender. False. Because before you even get to superior court, you have to file a felony complaint in the youth part. So you file it in Judge Gerald's part, and that's how the action is commenced against a kid in the youth part. 5, the filing of an indictment against a defendant who has never been held for the action of the grand jury. So that's true. So that's the silent indictment. 6, the filing of a felony complaint charging a JO with a crime enumerated in CPL 1.20 sub 42 with the youth part of superior court. True. 7, by filing of a superior court. Okay, I'm not going to read this because it's wrong. It's not even a possible scenario. And I think it's kind of a repeat of one of the things I said before. But anyway, you should have gotten the answer is 2, 5, and 6. Everything else is wrong, so it's C. Okay, 38. Oh my God, it's a lot to read. Select the best answer. When does periods... Okay, so basically it's a lot of stuff, okay? 30-30 gives a lot of ways that the DA won't be charged time. And I'm about to read you 5 of them, despite my horrible sore throat and my voice sounding like total shit, which I apologize for. Okay, so this is 30-30 sub 4. In computing the time within which people must be ready for trial, ... the following periods must be excluded. 1, reasonable period of delay resulting from other proceedings concerning defendant, including but not limited to competency proceedings, discovery, motions, and the period during which such matters are under consideration by court. True. 2, period of delay resulting from a continuance granted by court at the request of or consent of defendant or his counsel. True. 3, under certain circumstances, period of delay resulting from absence or unavailability of defendant. True. 4, the period of delay resulting from the detention of the defendant in another jurisdiction, provided that the DA is aware of such detention and has been diligent and made reasonable efforts to obtain presence of defendant for trial. 5, periods of delay occasioned by exceptional circumstances, including but not limited to period of delay resulting from a continuance granted at request of DA. If the continuance is granted to allow DA additional time to prepare the people's case, and additional time is justified is just an additional time the people's case. and additional time is justified by the exceptional circumstances of the case. So the answer was C. It was all of those plus others that I didn't list. 39, 100.15. An information, misdemeanor complaint, and a felony complaint must all do what? 1. Specify name of court where it's filed. True. 2. Specify title of action. True. 3. Be subscribed and verified by a person known as complainant. True. Contain an accusatory part and a factual part. That's also true. So, this again, it's always the two complaints and the information is the ones that have to be verified. And they contain both the accusatory part and a factual part. Okay, this next one is false. It's false because the word substitution is not in there. So I'm going to read it to you as if it were true by removing the word substitution. And this is in 100.45. At any time before entry of plea guilty to or commencement of a trial of an information, the court may, upon application of people with notice to defendant and opportunity to be heard, so not a hearing, just opportunity to be heard, order the amendment of the accusatory part of such information by addition of account charging an offense supported by the allegations of the factual part of such information and or any supporting depositions which may accompany it. In such case, defendant must be accorded any reasonable adjournment necessitated by the amendment. So what this is talking about is, let's say, like in New York City, we're used to the DAs writing the charges, but when I worked in Nassau, the DAs don't write the charges, the cops do. So the cops might write something out and then forget to actually charge the person with a crime that, if you read all the facts, the elements of the crime are all enumerated in the fact pattern. So the DA can add charges if they're supported by the facts that are alleged, but not substitute, because that would not be okay. And it has to be before they plead guilty or commencement of a trial. So that's important to note, that once a trial has commenced, they cannot add counts to an information. Obviously, the rules for indictment are quite different. Okay, so next one is also false, because it's not just motor vehicles. It's also the Commissioner of Environmental Conservation and Commissioner of Parks. So every simplified information must be substantially in the form prescribed by the Commissioner of Motor Vehicles, Commissioner of Environmental Conservation, and the Commissioner of Parks. Number 42, in calculating the time period limitation applicable to commencement of a criminal action, the following periods shall not be included. 1. Any period. Okay, so again, this is different from the 30-30 thing that was talking about, like, mental proceedings and, he agreed to a continuance and everything. Okay, this is different. This is talking about what periods are not included for timeliness of prosecution. Okay, not speedy trial. 1. Any period following the commission of the offense during which defendant was continuously outside the state, or the whereabouts of the defendant were continuously unknown and continuously unascertainable by the exercise of reasonable diligence. It has to have reasonable diligence to be considered continuously unascertainable. However, in no event shall the period of limitation be extended by more than 5 years beyond the period otherwise applicable. So, the answer is C, 5 years. But what you want to get out of this is, if, let's say, the defendant is outside the state for 7 years and he committed a misdemeanor, that's still too long, because you would get the 2 years for the misdemeanor plus the extra 5 because you're outside the state. But once it goes beyond the added 5 years, it's over. 43. A criminal action is commenced by the filing of an accusatory instrument in a local criminal court, or in the case of an adolescent offender or a JO, other than an adolescent offender charged with a violation or traffic infraction only, the youth part of the superior court. 44. A court may extend the period for requesting a supporting deposition if you make a motion. However, no motion may be brought after 90 days has elapsed from the date defendant is directed to appear in court, as such date appears on the simplified information and or upon the appearance ticket. So C, 90 days. 45. A verified or written accusation by a person filed with a local criminal court or youth part of superior court charging one or more person with the commission of one or more felonies is a felony complaint. Now, if it has a felony in there, it can only be a felony complaint. Because if you have to have a felony, it's got to be a felony complaint. Because an SCI and an indictment don't have to have a felony. They just have to have a crime. They can have a misdemeanor in there and not a felony. But a felony complaint, got to have a felony. All right, 46, true. A felony complaint may never be used as a basis for prosecution. That is true. It always has to be reduced, or the person has to be indicted, or an SCI has to be filed. You can never prosecute someone or take a plea to a felony complaint. All right, number 47. All right, so this question, in my opinion, this question is completely botched. And I worked hard on it, I think, and I don't know where I went wrong. I think I went wrong because I meant to put in number 1 that it was gonna be filed at the direction of a grand jury, but I forgot to say that, and then I was gonna trick you with any local criminal court. But whatever. The point is, when you take the test, there's going to be questions like this that have no right answer to do except try to pick the best possible answer. So, in my opinion, the best possible answer still was C. Because you didn't have the option to have everything except 5. Okay, and we know that 5 is definitely false. Because prosecutor's information is not verified, right? Prosecutor's information does not contain a factual part and therefore does not need to be verified. So let's say that we have the best answer should have been it should have been 1, 2, 3, 4, 6, 7. So let's read all these about a prosecutor's information. It's a written accusation by a DA. And if it's filed in a local criminal court, that is true. I don't know why I didn't say that. All right, 2, it may be filed at the direction of a local criminal court pursuant to 18050 or 18070. True. 3, it may be filed at DA's own instance or at direction of a superior court or at direction of grand jury. Also true. 4, it may charge one or more persons with the commission of one or more offenses, none which is a felony. 5 is false. 6, it serves as the basis for prosecution. True. 7, it commences a criminal action only when it results from a grand jury direction issued in a case not previously commenced in a local criminal court.